in the last 52 years. The only two times it has gone in, as the chairman said, whereas Buck, I guess...
We're recording the rest of this news conference, and we'll bring it to you here on C-SPAN in our overnight programming. Going live back to the House now, gaveling into session for debate on a bill dealing with state child abuse penalties.
6 of Rule 20. Any record vote on the postponed question will be taken later. For what purpose does the gentleman from Georgia seek recognition?
Mr. Speaker, I move that the House suspend the rules and pass H.R. 3627, the Kilah Davenport Child Protection Act of 2013.
The clerk will report the title of the bill.
Union Calendar Number 206, H.R. 3627, a bill to require the Attorney General to report on state law penalties for certain child abusers and for other purposes.
Pursuant to the rule, the gentleman from Georgia, Mr. Collins, and the gentleman from New York, Mr. Jeffries, will each control 20 minutes. The chair recognizes the gentleman from Georgia.
Thank you, Mr. Speaker. I ask unanimous consent that all members have 5 legislative days within which to revise and extend their remarks and to include extraneous materials on H.R. 3627 currently under consideration.
Without objection, so ordered.
Mr. Speaker, I yield myself such time as I may consume.
Gentleman is recognized.
The bill under consideration today, the Kilah Davenport Child Protection Act of 2013, is named after a young girl from North Carolina who was brutally beaten by her stepfather just last year. Her stepfather was charged with felony child abuse and awaits trial. Kilah, who was only 3 years old at the time of the attack, will face a lifetime of brain damage and paralysis at the hands of someone who is supposed to love and protect her. Stories like Kilah are absolutely tragic, but they are not uncommon across our country. Approximately 3.5 million cases of child abuse involving 6 million children are reported every year in the United States. In my own state of Georgia, there were over 37,000 reports of child abuse and neglect, with over 15,000 substantiated incidents of abuse in 2009 alone. And the rates of child abuse are even higher in Indian country, where Indian children experience child abuse at a significantly higher rate than the rest of the population. Adding to these tragedies is the fact that child abuse cases are not always reported and oftentimes not prosecuted with the same vigor as other crimes. Studies have found that charges are less likely to be filed against perpetrators in child abuse cases than most other felonies, and these cases have lower incarceration rates than other crimes. H.R. 3627, introduced by Mr. Pittenger of North Carolina, will help draw attention to how child abuse cases are handled across the country by requiring the Justice Department to issue reports on criminal penalties for child abuse in the 50 states, the District of Columbia, and the U.S. territories. This report is focused on state statutes because most child abuse cases are handled at the state level. However, there are parts of the country where the federal government has increased law enforcement role, such as and including Indian country. H.R. 3627 helps to strengthen the federal response to child abuse and other forms of domestic violence in Indian country and the special maritime and territorial jurisdictions by amending 18 U.S.C. Section 117 to allow prior convictions for the abuse of a child to trigger the offense of domestic assault by a habitual offender. This is a small but important change to the statute that will permit the federal government to prosecute more violent offenders. I commend the gentleman from North Carolina, Mr. Pittenger, for drawing attention to the terrible crime of child abuse and encourage my colleagues to support this legislation. And with that, I reserve the balance of my time.
Gentleman from Georgia reserves. Gentleman from New York.
Mr. Chairman, I yield myself such time as I may consume.
The gentleman is recognized.
Today we rise to consider H.R. 3627, the Kilah Davenport Child Protection Act of 2013. This legislation is part of the continuing effort to stamp out the scourge of child abuse in our society. According to the organization Child Help, each year there are more than 3 million reports of child abuse in the United States. At least 6 million children are impacted on an annual basis. Every day, an average of 4 to 7 children die in this great country as a result of child abuse and neglect. And more than 78% of reported child fatalities resulting from abuse and neglect were caused by one or more of the victim's parents. We must do everything in our power to change this sad reality. Our effort, of course, must be comprehensive and should include both robust criminal justice enforcement and parental education and prevention efforts. In other words, our approach should be balanced. Those who abuse children must understand that the consequences connected to their criminal behavior will be significant. We must also aggressively take steps to prevent child victimization before it occurs. In doing so, we can mitigate the severe trauma of child abuse and simultaneously channel precious taxpayer resources away from the criminal justice system. H.R. 3627 requires the Attorney General to issue a report regarding the penalties for violations of laws prohibiting child abuse in the 50 states, the District of Columbia, and U.S. territories. This report must consider, of course, whether those laws provide enhanced penalties when the victim has suffered serious bodily injury or permanent or protracted loss or impairment of any mental or emotional function as occurred in this tragic case referred to in North Carolina. This reporting requirement is a good step toward helping Congress accurately evaluate the statutory landscape in the child abuse context and govern in a more informed fashion. In addition, the legislation permits prior convictions for assault, sexual abuse, or serious violent felonies to be used to trigger additional penalties for habitual domestic abusers on Native American reservations and in special maritime and territorial jurisdictions. This trigger will better protect potential child abuse victims from repeat offenders. For the above referenced reasons, I urge my colleagues to support this legislation, and I reserve the balance of my time.
Gentleman from New York reserves. Gentleman from Georgia.
Thank you, Mr. Speaker. At this time, I'd like to recognize the author of this legislation, a gentleman who has a great passion for this issue, the gentleman from North Carolina, Mr. Pittenger, for as much time as he may consume.
The gentleman from North Carolina is recognized.
Thank you, Mr. Speaker. Thank you, Mr. Collins. I rise today on behalf of precious Kilah Davenport, a sweet little girl at the age of 3 years old, was taken by her caregiver and bashed her head against the wall. As a result, Kilah has suffered irreparable damage to the extent that at this point she is immobile and she's paralyzed and has suffered severe brain damage. You can see pictures right here of Kilah, a young girl, and then the next day the condition that she's in. She's made some progress. Her family's encouraged. They assist her 24/7. It's changed their lives. But to the credit of the Davenport family, they wanted what occurred to their child to make sure that that never happened again. And they focused their intention and their efforts, their commitment to passing a law in North Carolina, where I live. And now we have a statute that gives a minimum sentence of 10 years to anyone who's convicted of this type of egregious child abuse. Prior to this time, the minimum sentence for such an abuse was 4 years, maximum 6 years. This type of severe cruelty warrants a measure of sentencing commensurate with what has been enacted. And so I congratulate my colleagues whom I served with at one time in the North Carolina Senate and House, Senator Tart, Senator Tucker, Senator Curtis, House members Horn and Arp, for the leadership that they gave in North Carolina and provided what will be, I truly believe, a real model for the rest of the country. Because, Mr. Speaker, the purpose of the Kilah Davenport Child Protection Act is to give a basis for other states, appealing to them through their attorney generals to issue these reports, the first one in 6 months, the next one 3 years following, of their current statutes on child abuse and their sentencing. We have found in many states that there are very minimum and lax sentencing. In the South, there's one state that it's a year and a day could be the maximum sentence. One state in the Northeast is 7 years. One state out west is 5 years, is the max sentence. This shouldn't be. We feel like there's many states, who, once they understand how limited the scope is of their sentencing, that they would want to change it. And yes, Mr. Speaker, I do believe that these types of bills are better addressed in our states. I believe that other states will take the proper action, as North Carolina did. And as I have consulted with law enforcement and with judges who handle child abuse daily, that's why I introduced H.R. 3627, which is a bipartisan legislation that will address this severe need to make sure that children in the future are not harmed in the same way. This bill will ensure that those who suffer serious bodily injury, mental and emotional disparity in function would be addressed with the types of sentencing that would warrant the type of crime committed. I believe, Mr. Speaker, that as we enact this bill, that we will see a tremendous impact throughout the country to prevent this type of scourge from occurring again. So I commit it to our Congress. I thank the great support of the members to make sure that this bill is enacted. I thank Senator Burr for his leadership in the Senate, and I yield back the balance of my time.
The gentleman from North Carolina yields back the balance of his time.
Mr. Speaker, we will reserve. We have no other speakers if you're ready to close.
Gentleman from New York.
Yes, I have no additional speakers and prepared to close. Let me just simply say I commend the gentleman from North Carolina for putting forth this measure in the House and helping to shepherd it hopefully into swift passage and then into law. And I also commend the Davenport family for their courage, their strength, their perseverance, and wish them Godspeed as it relates to the recovery of their child moving forward. And I yield back the balance of my time.
The gentleman from New York yields back the balance of his time. The gentleman from Georgia.
Mr. Speaker, just in closing, again, it is good to be with my friend down here, and also the bill that Mr. Pittenger is bringing forward is also common sense legislation. I think that strengthens our homes, strengthens our family, and addresses an issue such as child abuse and the real consequences the Davenport family are finding, but not just them, but many across our country. And with that, I'd urge all my colleagues to support this legislation. With that, I yield back.
The gentleman yields back the balance of his time. The question is, will the House suspend the rules and pass Bill H.R. 3627? Those in favor say aye. Those opposed, no. In the opinion of the chairs, two-thirds being in the affirmative, rules are suspended, the bill is passed, and without objection, the motion to reconsider is laid upon the table. The chair lays before the House a communication.
The Honorable, the Speaker, House of Representatives, sir. On December 4, 2013, pursuant to Section 3307 of Title 40 United States Code, the Committee on Transportation and Infrastructure met in open session to consider resolutions to authorize 5 lease prospectus, including in the General Services Administration, GSA, FY 2011, FY 2014, Capital Investment and Leasing Programs, CILP. Our committee continues to work to cut waste and the cost of federal property and leases. The resolutions approved by the committee will save the taxpayer $12.9 million annually, or $193.6 million over the terms of the leases. These resolutions ensure savings through lower rents and shrinking the space requirements of agencies. With these resolutions, the total savings for GSA prospectus approved by the committee this year is over $668 million. One of the resolutions approved on December 4 is for a lease replacement of the Nuclear Regulatory Commission, NRC, in Rockville, Maryland. This was an outstanding lease prospectus submitted as part of the FY 2011 CILP. While other agencies agreed to reduce their space footprint and reduce cost, NRC has not done so. After working with the NRC and GSA, the committee brokered an agreement that will put 1,100 additional employees into NRC's buildings by having space backfilled by the Food and Drug Administration, FDA. As a result, FDA has agreed to relinquish 4 leases that will save the taxpayer $145.8 million. Letters from the NRC and FDA acknowledging this agreement are enclosed. I have also enclosed copies of the 5 resolutions adopted by the Committee on Transportation and Infrastructure on December 4, 2013, Signed sincerely, Bill Schuster, Chairman.
Referred to the Committee on Appropriations. The Chair lays before the House Communication.
The Honorable, the Speaker, House of Representatives, sir. Pursuant to Section 1238B3 of the Floyd D. Spence National Defense Authorization Act of Fiscal Year 2001, 22 U.S.C. 7002, amended by Division P of the Consolidated Appropriations Resolution 2003, 22 U.S.C. 6901, I am pleased to reappoint the following individuals to the United States-China Economic and Security Review Commission: Ms. Carolyn Bartholomew of Washington, D.C., and Mr. Jeffrey L. Fedler of Great Falls, Virginia. Thank you for your attention to these appointments. Signed sincerely, Nancy Pelosi, Democratic Leader.
The Chair lays before the House a message.
To the Congress of the United States, pursuant to Section 233E1 of the Social Security Act, as amended by the Social Security Amendments of 1977, Public Law 95-216, 42 U.S.C. 433E1, I transmit herewith an agreement of Social Security between the United States of America and the Swiss Confederation signed at Bern on November 3, 2012, the U.S.-Swiss Agreement. The agreement consists of two instruments, a principal agreement and an administrative arrangement, and upon entry into force will replace the agreement between the United States of America and the Swiss Confederation on Social Security with final protocol, signed July 18, 1979. The administrative agreement between the United States of America and the Swiss Confederation for the implementation of the Agreement on Social Security of July 18, 1979, signed December 20, 1979, and the supplementary agreement between the two contracting states, signed June 1, 1988. The U.S.-Swiss agreement is similar in objective to the Social Security agreements already in force with most of the European Union member states, Australia, Canada, Chile, Japan, Norway, and the Republic of Korea. Such bilateral agreements provide for limited coordination between the United States and foreign Social Security systems to eliminate dual Social Security coverage and taxation, and to help prevent the lost benefit protection that can occur when workers divide their careers between two countries. The principal updates encompassed in the agreement include amendments to rules for entitlement to the Swiss disability pensions paid to ensure equality of treatments between U.S. and Swiss nationals, upon the personal information and confidentiality provisions and modifications necessary to take into account changes in U.S. and Swiss law since 1988. The U.S.-Swiss agreement contains all provisions mandated by Section 233 of the Social Security Act and other provisions that I deem appropriate to carry out the purpose of Section 233 pursuant to Section 233C4 of the Social Security Act. I also transmit for the information of the Congress a report prepared by the Social Security Administration explaining the key points of the U.S.-Swiss agreement, along with a paragraph-by-paragraph explanation of the provisions of the principal agreement and administrative arrangement. Annexed to this report is the report required by Section 233E1 of the Social Security Act on the number of individuals affected by the agreement and the effect of the agreement on the estimated income and expenditures of the U.S. Social Security program. The Department of State and the Social Security Administration have recommended the U.S.-Swiss agreement and related documents to me. I commend the U.S.-Swiss agreement on Social Security and related documents. Signed, Barack Obama, the White House, December 9, 2013.
Referred to the Committee on Ways and Means and ordered printed. For what purpose does the gentleman from North Carolina seek recognition?
Mr. Speaker, I ask unanimous consent that when the House adjourns today, it adjourn to meet at noon tomorrow for morning hour debate and 2 p.m. for legislative business.
Without objection, so ordered. For what purpose does the gentleman from North Carolina seek recognition?
Mr. Speaker.
Does the gentleman have a motion to adjourn?
Yes, Mr. Speaker, I do move that the House adjourn.
The question is on the motion to adjourn. Those in favor say aye. Those opposed, no. The ayes have it. The motion is adopted according. The House stands adjourned until noon tomorrow for morning hour debate.
After debating one bill this afternoon dealing with state child abuse penalties, which was approved by voice vote, the chamber is done with legislative business for the day. House leadership is waiting for several bills to be ready for floor action, including an updated farm bill, a federal budget agreement, and legislation to delay a 24% cut to Medicare payments to doctors. We'll have more live coverage of the House tomorrow here on C-SPAN.